So Jitendra ji, so can we start this session? So we have today we are talking on the legal and compliance side, specifically on the startup ecosystem. So Jitendra ji, please you can start discussion.
So there are so many things. So we will take this session, Vinayak and Mohit. So we will start from the basics. Okay, then we will move into a little more in-depth practical aspects we are seeing, over the year, and so many matters are settled down. Some are still, there, which need to be settled down. Okay, and there are certain gray areas as per Indian law, because startup industry all over the world is quite dynamic, but law, everyone knows that it's not quite dynamic as per the changes required in the startup industry. So we will discuss some of the gray areas also, and then we will move to question answer from the audience. In between, if we find some question answer relevant to our discussion, then we will take up front rather than waiting for the end of the session. So audience are happy to ask questions with the relevant point, so that we can take it upfront, and so that make it a more beneficial for audience and to the promote
Okay.
also. Yeah.
So I am just repeating what Jitendra has said, that audience, if you have any questions in your mind during the discussion, you can put it in the chat box. We will try to take all the questions in between the session, but only the relevant questions will be taken care of, and rest other questions we will be replied after this session.
Yeah.
Yeah. Yes, Jitendra ji. So you
Yeah.
can start discussion, sir.
So, Vinayak, let's start from the basic. If there are a team, the founder team is there, they have the idea and they want to just start their business. So what are the basic things they need to do? Just like they just go for the incorporation of the entity setup, or before set up an entity, there are certain requirement they need to do from the legal aspect, from equity participation and all that, or some kind of agreement they need to do. So just give your thought on that, so that there are many budding professional and many budding entrepreneurs are here, so they can get the idea how to go about the startup. Yeah.
Sure. Thank you. Thanks, Vishnu. Very relevant question. Maybe the intro could not happen properly because we went into some other professional issues. Hi, everyone. I am Vinayak. I am a corporate lawyer by training, and have been working on the VC ecosystem for past 6-7 years actively. Before that, I was mainly doing private equity and M&A transactions. Started my career with a Bombay-based solicitor firm called Desai and Diwanji, from where we moved to BMR Legal, and from there to Shardul Amachan Mangaldas. I left Shardul Amachan Mangaldas in late 2019 to set up my own practice, and then was partnered with a leading VC-focused law firm called Algo Legal before joining Lightspeed. At Lightspeed, I take care of the legal function for Lightspeed for India and Southeast Asia. And we invest not only into Indian startups, we also invest into Singapore startups and the entire Southeast Asia region. So talk about Malaysia, Indonesia, Singapore, Thailand, even and a lot of investments happen in the United States. And being a versatile firm, and being a firm which is not focused on any particular check size, we kind of see all stages of startup as well. Like at times, there may be, like I have seen startup ecosystem evolving in India in past 6-7 years, wherein when Cred raised its first Series B, the Series B at Cred was around 120 million. So I was definitely part of that round, and that was the biggest Series B of that time. Recently, one of our portfolio companies raised a Series A, which was close to 100 million, and which was the largest Series A in the Indian startup ecosystem. So the definition of startups is itself changed in common parallels, and now a lot of established companies with a lot of known founders who are starting up after maybe their second inning, third inning, they also launch companies, and therefore the definition of startups has drastically changed from where we started practicing in this area. Having said that, one of the key issues that startups face when they go for fundraising is at times not having paid sufficient attention to compliances at the very beginning of the company, right from incorporating the company properly, choosing the right jurisdiction, choosing the right form of incorporation, uh, whether you have the right objects in your memorandum so that you may attract foreign capital. These are questions that you normally face when you do your first fundraise, and therefore having been advised by good advisors right from beginning is very important. When I used to uh, be on the practicing side of law, when I was with law firms, I used to always advise founders that once you have raised money, it's fine to be bootstrapped initially, but once you have raised money, you should always look for reasonably good advice from your advisors, and not try to over optimize on saving money at the cost of quality of advice. So that's something that I have found very pivotal in any startup journey towards growth. Because at times, a lot of time gets wasted on the founder's part, on the company's part, in undertaking these compliances later when the round is in progress, and therefore a lot of things are highlighted by investors as red flags at that point of time. So maybe it's something that you should always consider when you start up. I understand a lot of audience here is also comprising of founders or people who are aspiring to start up. So maybe at the initial phase of the business, it's of course very much important that you focus on the business and scaling, but maybe you should not uh, put compliances on a back burner. At least the minimum compliance should be met when you start the business. For example, I'll just give you some examples, and I was just making a list some time back when I had talked in a similar forum.
Yeah. Yeah.
Things as simple as not maintaining minutes properly or not documenting minutes gives a picture of mismanagement, uh, or not that savvy management on the part of founders and the company, right? So having proper minutes for the meetings is very much important. We at Lightspeed advise our companies that when they are doing their meetings, they at least a lawyer, and if not a lawyer, a company secretary should be present in that meeting so that those meetings are recorded. Now, multiple times you may see that meetings are not formally done, and you catch up with the stakeholders in a more informal meeting, like you do a Zoom meeting and you basically just go ahead with that. Maybe it's always good to have someone still there in that meeting recorded, and just term that meeting as a formal board meeting. So whatever you had to discuss otherwise over Zoom call, maybe apply the procedure in the Companies Act, have it convened as a formal board meeting. Let the minutes be taken for that, because ultimately, and while Companies Act requires that there should be minimum 4 meetings in a company's financial year, uh, any good company which has a good corporate governance, I have not seen such companies not having at least 20-30 meetings in a year with the stakeholders. So that's something that would keep happening every week, every second week, every third week. You will meet with the stakeholders of the company. Just have those meetings converted to a formal board meeting. Have that recorded properly, so that when your company is diligenced, people doing diligence get a sense that yes, this company has followed good corporate governance practices and is doing what it is required to give comfort to people. They take the stakeholders along, and it's not that the company is run in an autocratic manner. So that is one example that maybe I can give you.
Yeah.
If you are if you are into manufacturing, make sure that you meet all the compliances. Compliances are very heavy in manufacturing sector. If you are in real estate, that's something that you have to ensure that you meet all compliances. If you are in financial services, where there are sector regulators like insurance, for insurance, there's IRDAI, there's RBI for other fintech products. there is SEBI for any investment advisory. So those sector specific licenses is something that you should always focus on and procure at the time that you're launching your business or whenever they become applicable, because at times a lot of rounds get stuck because of this as well. One common mistake that maybe I have seen startups making is not having a ESOP pool, but not adopting a ESOP plan.
Yeah.
Under Companies Act, you cannot grant options before expiry of 1 year from the, options cannot be exercised before expiry 1 year from the date of grant. Multiple times, and I can say this with confidence and conviction because I have seen this live in many of my clients who delayed adoption of ESOP plan, but they had given or they had promised options to their employees who were joining them. And at times, the formal ESOP plan was not adopted for close to 2 years after the ESOPs were promised. And this creates bad blood amongst employees, creates a compliance burden on the company. Your cap table is uncertain because you at times lose track of who all you have promised ESOPs to. So again, adoption of ESOP plan is not a big thing. You could do it very easily at the initial stage of the company. So maybe you might as well do it just then.
Yes.
One of the common mistake I've seen Jitendra and Mohit companies doing is when you have attracted foreign capital, not following up enough for the FEMA filing acknowledgements.
Yes.
Right, sir.
Yeah, not tracking FCTRS acknowledgements.
Yes.
Delaying filing of PAS 3 as well. So these are things that maybe if you are having a good advisor on board, and as advisors for those who are on this call, it's our duty to advise our respective clients that these compliances may seem heavy initially, but ultimately they are for good of the company, and they will only help the company rise up a notch in the corporate governance ladder.
Yeah, because we have seen Vinayak, because in the startup industry you cannot ignore the compliances, because every 6 months or down the year you are raising fund, and there will be a due diligence carried out by a seasoned law firm or seasoned professional. So you cannot skip those compliances. You have to be overall compliant in a say that you can your DD will be smoothly, and there will be no unnecessary delay in the fundraise, right?
So Jitendra, I have one question for both of you guys. Generally, the majority of the startup founders grind themselves to innovate a product and disrupt the market, but focuses on the legal factors at the end. So my question is that how risky this approach can be. So the founders generally, they say they will look after the legal and compliances later on. They should focus on the first their core product, their operations and everything. So my question is, how risky is this approach is?
So
to Vinayak sir first, and then Jitendra sir can add on in this.
So Mohit, as I said, everyone understands that when you are launching a business, the focus is on growth and to scale the business up. But needless to say, and I have seen it firsthand when I used to be in law firm, because a counsel, when he's advising a client on a legal diligence, or when the financial DD folks are advising the client on a financial diligence, the client has also reposed a lot of trust on them, and therefore more often than not, and mostly, advisors would take conservative views on things. And therefore you may fall foul of multiple regulations, multiple things which may be legally in the gray area, but may not give comfort to the advisors. So my advice always to my clients has been that be as much compliant as you can. And if you get to know about it, get to the root of the compliance, and if applicable, do it. Ultimately, it bites you in a wrong time otherwise, because multiple times, and mostly you would see that companies are raising funds, and by the time they reach to that level, they have already burnt most of the cash. And then having these issues, A, gives discomfort to founders, at times gives discomfort to vendors and other stakeholders for that company. B, gives a wrong sense of the company to the investors. C, delays the round, because people have to find common ground, which could have otherwise been avoided by simply foreseeing these things.
Yes.
Mhm.
So there are many basic thing, Mohit. Its compliance is not that rocket science that everyone, because now we are in a era where everything is available on Google. So there are so many basic thing, basic compliances everyone aware when they just, I would say, when the founders go for the incorporation of company, the person they getting the incorporation, they should be choosing the good person, and they should make sure that they just not done with the incorporation. They should ask them what are our regular compliances. It take hardly 15-20 minutes to understand what are the basic compliances during the year will happen, and what kind of mistake they would. So a very good example, many companies in the startup, they take loan from their friends, just individuals, which is a very strictly no into the companies act, because that will be a deposit. So but they don't have any idea, have any idea about that. But so I would say the duty of professional is also there, so they should not just do the service of incorporation or setting up the business. They should also guide them, or I would say handhold them, that these are the things you should take care, basic things they should let them know, these are the basic things you should take care, and you should avoid these things at any cost, and these are the problem you will be facing if these are the thing we will carry on. Okay, so that will save lots of cost, lots of money, lots of time, and lots of mental disturbance also. Yeah.
Okay. So I want to add one more thing. I have just recalled my mind. There was an company in the year 2011 called Blue Gap. They were the startup companies, and they were doing very well. They reached at the level of rupees around 1 crore of revenue monthly, but they suddenly faced some legal challenges. They faced some legal challenges related to the copyrights, because they were into the operations of the fan arts. So they are selling, they are creating the fan arts, and they are publishing these through their portal. So due to these legal challenges that they have not envisaged before they have started this operation, but after some time the real artist gave the notices, legal notices, and they has to shut down their businesses. So my point to recall this incidents is that when any startup is starting any business, not only the TDS, GST, only the patent and the trademark. So there are certain basic legal compliances which is necessary, which can hamper their business, their day-to-day operations, that has to be taken care of it. Like in the food and beverages market, the QSR industry, they has to take their FSSI. So similarly, so these type of licenses and these type of registrations and the legal compliances, which is very necessary for day-to-day operations, has to be taken care from the day one. Not only that after the having some revenue, some reaching the stage of the level. So my point is that the approach of the founders, that they will handle the legal and compliances later on, once they will settle down their product and the process. So my point is they should focus legal compliances from the day one, and this is the recommendation from our side, because we are the professional background also in this.
Yeah.
Yeah.
So yeah, so I would just go back before we prior to the incorporation, Vinayak. So just let's say there are a team, they want to start a startup. So what do you suggest? Like they have built some technology before setting up of the company. What kind of agreement, let's say, whether it is necessary to go into a co-founder agreement or not, or whether it is mandatory to go technology transfer, or any other agreement which you suggest, this should be there in place, so that in the future there won't be any conflict, or there won't be any problem during the due diligence. Yeah.
So is the question around IP, Jitendra, like when you create IP?
Yeah, it will be around IP also, whether they will be co-founder, because we have seen many times, the co-founder virtually agreed between them about shareholding, but later on nothing is on paper, and there are so many conflict between the promoters. So what kind of things you would suggest, that what kind of agreement they should have in place before uh, going into the formalization of business? Yeah.
Yeah, of course. So again, Jitendra, this is something that uh, I would say is the answer is very simple. Uh, at the end of the day, all the founders are human beings, and
Yes.
human beings have different aspirations in life, right? You may be best of friends right now when you start up, but as the
Yes.
company grows, there may be differences between you.
Yes.
At times, merely stemming from the fact that you have more command over the business than your other co-founder, or maybe when the company started, both of you were contributing equally to the company. But later, because the company pivoted into a model that is more of a domain of founder A and not founder B, founder A is taking natural lead in the business.
Okay.
So when founders come together, I would say that it's nothing short of a JV. And when a joint venture is created, you of course document the rights, responsibilities of venture partners, their obligations, their shareholding, how would they make contributions to the business, what would be their specific role in the business. So I think having a co-founder agreement inter se between the founders is very important. It's also very important that if you have created a company, all the IP that the company generates or all the IP that the employee generates should be assigned to the company from the very beginning.
Yeah.
Uh,
Yeah.
the if
Yeah.
you yeah sorry
Yeah, IP, and we have seen many times, even the trademark also, and the domain name also. We have seen during one of our client also, Vinayak, which you were also there at that time. So we have seen that the trademark and domain name, everything is registered in the name of the founder rather than in the company. So it was a CP item during the due diligence, that before the funding round we have to move to the company name. So it is also suggested that whenever you are going for the everything, so whatever IPR, whatever domain name, everything should be in the name of company rather than the promoter name. Uh, yeah.
Vinayak, one audience has asked one question, Mr. Jitesh Agarwal. This is related to the very recently case of the Mantra logo. So his question is that what step should startup take to ensure their logo is not offending sentiments? So what do you suggest in this?
I think
So like Mantra has did something wrong, so they could not think about this sentiment. So
So
what is your view on this?
so Jitesh, again, the answer to this is, and Jitesh rightly pointed out the answer itself in the question.
Mhm.
Uh, when you are launching something, have the logo, have the design blessed by experts, for the reason that you never know. Like, getting a trademark registration is a long journey. It's not that you get
Mhm.
a trademark registration overnight. And
Correct.
you may just want to avoid being in that phase of seeing an objection, seeing an opposition, fighting it out, going to trademark registry. So whatever you can mitigate before filing of the trademark application or before even launching the logo, you should always do it.
Mhm.
Having said that, whatever precautions you may take, at times it's not enough, right?
Mhm.
If a particular logo offends the emotions of a particular class or a particular group of people, that's something that again you may not be able to forecast for that immediately. At times you would see a lot of these ads which are spoofs, right? Some people may take it in a funny way. Some people may say that uh, this is a kind of advertising which should not be promoted. At times courts have also held against it.
Mhm.
So it's always good to have your ad campaigns, your logo, your name for the company blessed by people before you go ahead and use that. I
Correct.
think in past also I have seen with a couple of CSS who have advised that before you even apply for a name to ROC, you have it blessed
Mhm.
by a trademark attorney. And this we used to
yes.
do for the clients when I was in law firm, that before you apply for registration for a name or even trademark, you have it blessed by the attorney who are experts in this.
Correct, correct. Very well said. Very well said, sir. So,
Yeah.
Jitendra, can I take one questions
Yeah, you can.
related to the due diligence?
Yeah, please.
Because the Vinayak sir has a great experience in the due diligence. So Vinayak sir, I want to understand that what type of red flags generally you see when you do the legal due diligence of any startup companies. So what the startup company should take care of that, and so give some experience.
So
So what is
I would rephrase the question, Vinayak,
yes, please.
a little bit. So, what kind of the red flag you have seen where we have seen there are some non-compliances, but we can do those compliances on later stage, and we can go for compounding. But sometimes you have seen so many red flags that you just from the investor side, I'm just taking this asking this question, where the investor just stop the entire funding,
Investment actually.
the investment itself. So just give us about some brief about those red flags where investors just stop the investment round because of those.
Basically that hurts the investment.
Yeah.
Yeah. Okay.
So in my experience of past 14 years of investing, 98% of times a deal is not stalled because of legal issues.
Yes.
Oh,
Uh,
98%, sir, you are talking.
Yes.
98% of times deals are not stalled at because of legal issues, but
Oh.
deals get prolonged, which would kind of make the founders or the company lose the edge that they would have had otherwise had they had those funding, which is as good as at times the company. I can give you one example. We were working on an e-commerce startup, wherein we found that like many of the companies were structured abroad at that point of time. Even this startup had a foreign holdco and had a India sub, and they went ahead with it with the advice of a CA, saying that this is something that so and so company have done. All the Flipkart and Shoploos of the world have done this, so there should not be an issue. And we will also have a foreign parent and a India subco, because holding IP abroad is always good, and you would be able to attract more foreign investors in the company, which is headquartered abroad. What we found during diligence was that the money was routed through LRS by Indian residents and put in the company abroad. And therefore, as most of you would be aware of that if you route money through LRS into a company, which is liberalized remittance scheme by RBI, and you invest into a company abroad, that company cannot have a subsidiary anywhere in the world.
Yes.
So that became a red flag, and we had to kind of unwind the entire structure, rewind it, and reset up the company, which took around 3 months. And in those 3 months, this startup, which had a very novel idea, multiple people copied that idea, raised funding, because if you have a good structure, funding can be done as quickly as within a week. Like we have done funding within 4 days, 3 days, a week as well, if the company has been properly set up, right? So they lost their startup advantage, and that kind of, in a way, was a nail in the coffin of the company at the very beginning. So these are so there are legal red flags as well, which may result in the company not being able to take off. In some scenarios, you see that the business model of the company had not been blessed. We know that all the companies are starting up, and they are at times in the gray area, but we should always avoid the darker shade of gray without maybe having had a legal backup of that idea. So you should always, if you are starting with an idea which no one has done it, and which you may feel that there may be some gray area around that, please have it blessed by a good lawyer, a good company secretary, or who understands how businesses are structured, and who has visibility on uh, how an investor may look into this, or how a regulatory authority may look into this. Because at times things which seem very naive are basically troubled propositions.
Yeah.
Okay. Okay. Very well said. Very well said, sir. It is very strange to me that 98% you are saying that the proposal gets rejected of the investment
No,
just
no,
because.
no.
Yes,
Proposal get
no. I said
accepted.
go
Okay.
through.
No, you take it wrong, guys.
Okay.
98% legal, due to legal, the deal will be not halted. It will go through. So
Okay.
only 2% is there
Deal would
where
still
the
go
deal will.
through. Yeah, deal would still go through unless there is a super big red flag.
Yeah.
Deals go through, and I said that in past 14, 15 years of experience of mine, I have not seen deals having been dropped because of legal diligence issues. Maybe one or two times it
Okay.
has happened, but that too,
Okay.
the issues have been like something that are earth shaking.
Yeah.
Oh, okay.
So,
Okay.
yeah, Vinayak, move forward. So I would ask, so we have seen, in the early stage of the startup, many founder, what they do, they just copy paste the SHA. They took the format from Google and they just copy paste and they give unnecessary rights to the investor. Even they are investing very small amount, or even they are investing 1% or 2% in equity into the company, but they ended up giving them huge rights, just like ROFR, affirmative vote right, matter for per se. So what I though you are from the investor side, you are working with the investor side, but you have seen the other way also. So what your guide to the founders, so what kind of rights they should give, or what kind of right they should not give at the early stage of their startup and early stage seeds funding. So just give it a little light on that also.
Sure, Jitendra.
Okay.
Uh, Jitendra, I would say that, and this is something that I used to advise all my clients as well when I was a independent lawyer. Taking money from an investor is getting into a marriage, and you should do as much diligence when taking money from an investor on the investor as you normally do on the prospective spouse in a arranged marriage, so to say. So,
Yes.
so, so one of my ex seniors used to always say that if you have taken money from an investor, you have kind of invited a guest into your house, and now that guest would not leave. And imagine a scenario wherein that guest has come in and his hands are dirty and he's putting his hands all over the walls in the house, right? So
Mm-hmm.
basically, when you are letting someone into your brainchild, into a company that you floated, which you created with some vision, you should always ensure that there is huge alignment between you and the investor. Do not take money from an investor because uh, do not take money from an investor because just because the money is available, or because X investor is giving you a higher valuation than investor Y. There should be proper diligence. You should always see that the investor that you're taking money from, what pedigree that the investor comes from. Especially HNIs have been very instrumental in promoting the startup ecosystem of India, and there are multiple plethora of HNIs who have gone ahead and helped companies which were not otherwise receiving funding from institutional investors, and which companies have not done phenomenally well. But even in the choice of taking money from angels and HNIs, be very selective and do a proper diligence on how this particular investor may behave in certain circumstances, so that you know as to whether these people are there to cheer for you from the background. They would come together with you and build the company with you, or they would just put money and try to get worth of that money throughout the journey of the company. Because the latter part of the investor would be the most difficult investors to deal with. And that brings me to your question, Jitendra. Uh,
Yeah. Sorry.
You basically,
Okay.
when you write anything in the document, remember that if you have a reasonable investor on the cap table, that investor would not ask for anything unreasonable or anything which is off market. B, even if you have written something that maybe you do not find very useful, or that's something you're not comfortable with, or that is something that the next round investors are not comfortable with, a reasonable investor would always be open to changing it in the next round, even before
Yes.
the next round at times. So therefore, uh, is, the answer to that is that your choice of investor should be very good, and that should solve half of the worries. The second part of it is that whenever you write something, whenever you sign a piece of paper, please have it reviewed by a good advisor, so that you know what you are signing up to. You may still sign the same document, but at least you are going in with this with your eyes open, and you know what rights you are giving to the investor, what are your obligations. At times, you would see that some term sheets may have very difficult provisions which are not seen in the market anymore.
Yeah.
But the investor has proposed it as something being very standard. So those are things that I think you should avoid, and that can only be done because each founder, each company secretary, each CA is not an expert in fundraising. So you should always have
Yes.
experts advise you on that.
Yeah.
Right, right. So, Jitendra ji, I want to ask this question again to you, even because you are also a company secretary and dealing with so many SSHA and SSA. So, you tell the audience that what are the terms basically in the SSA and SSHA that the startup should think twice before agreeing on that with the investor. So,
So
give
yeah.
us some glimpse of the few terms only that is very critical that startup should think twice.
So there are few things. Number one, I would say, unless or until the investor is investing in a huge, he is taking a substantial, equity percentage in your company. You should not give them, affirmative vote right. Number one, you should not
Affirmative
give.
voting right.
Yeah.
Okay.
Veto power, we say. You should not give them rofer. Okay, you should not give them board seats. So these are the three things I would say, ki unless or until, if they are taking 10% or 15%, then you can give these things to the investor. These are very well settled scenario in India, where up to that percentage shareholding, they will take the seat on the board, and they will take the anti-dilution you can give to anyone. They will take the rofer, and they will take the affirmative vote right. But below that, I would say they should think twice before giving to those. Yeah.
Okay. So just to give the just to I want to get the want to know the what is the affirmative right, because our audience maybe are not conversant with this term. So can you explain what is the affirmative right, sir?
So yeah, affirmative vote right is like,
Affirmative
affirmative
voting
vote
right.
right is
Yes.
like veto power. So whenever there are certain items, so these are the item, they will set a list of item which are substantially important, like merger, acquisition, changing the share
Mhm.
capital, next funding if you are raising another fund round. So there are certain list of the items. So
Mhm.
whenever you go to take those decisions, you have to take prior approval of the investor. Without their approval, you cannot do those transactions. So that's the affirmative vote right. That's like a veto power. They, yeah.
Okay. And because we are discussing the SSHA, so one more thing which is coming to my mind is generally in the SSHA, anti-dilution clause is there in almost in every SSHA. Basically, in every agreement, this clause generally be found. So
Yes.
how practical it will be to implement this?
So this will be the, I would ask this question from Vinayak,
Okay,
because he
Vinayak sir.
is much
Okay.
better to guide us in this. Yeah.
Okay, so Vinayak sir, please give us your insights on this. Okay, how the practicality will be in the anti-dilution clause when we put into the SSA.
So, Mohitji, you will see anti-dilution provisions being very standard in all VC transaction documents.
Yes, sir. Yes, sir.
Uh, Practicality of implementation. So I would say that I have seen this being implemented, and I have seen this being implemented quite often,
Okay.
provided there are enabling provisions in the company for giving
Mhm.
effect to anti-dilution protection. You may
Yes.
also see, so you would be aware that anti-dilution provisions are mainly of three kinds. You have a full ratchet anti-dilution protection. You have a
Mhm.
narrow-based weighted average protection, and you have a broad-based weighted average protection.
Mhm.
In
Okay.
in these scenarios, you would normally see that narrow-based weighted average protection has become kind of archaic right now, and you don't see it quite often. And as advisors, unless the company is entering into an area which is like very new, this is something that is best avoided. As in areas where valuations are not certain and you don't know what valuation the company may fetch, only in those cases narrow-based weighted average is seen. Otherwise, no good investor would ever ask for narrow-based weighted average, full ratchet protection. This next option is narrow-based weighted average protection, which is also unusual. And you would see mostly that broad-based weighted average protection is used in all transaction documents. You talk about any good VC, and mostly they would have broad-based as the formula available there.
Mhm.
With respect to these provisions, you need to normally have, if it's a non-resident investor, you need to normally have sufficient buffer between the fair market value of the securities at the time of issuance and the issue price.
Yes.
Without that, you may not be able to give effect to this by virtue of adjusting the conversion ratio.
Yeah.
If you are a resident, there is no restriction as such. However, any anti-dilution protection mechanism, when implemented, comes with its own tax risks. So that's a separate thing. Maybe we can cover it sometime later. But it always results in a lot of tax in the hands of the recipient of those additional shares.
Yeah.
At times, you may also see founders being required to transfer their shares to make good this anti-dilution protection, which is also quite frequent. Uh, Sadly, in India, there's not a lot of jurisprudence around this when people have implemented this. But as the law stands today, there's nothing illegal, and I can say that this is enforced quite a number of times.
Okay. Okay. Great, sir.
And there is another clause, Vinayak, I would like to ask you, and please, so reverse vesting, we have seen, the lock-in and reverse vesting for promoter. So just give some brief and light on that aspect also, the reverse vesting for promoter shareholding. Yeah.
No, sure. So, reverse vesting is a provision that, again, for me saw it for the first time some 7 years back when it, and it appears normally in the context of VC funding, not in case of a M&A or not in case of a PE funding, because those are senior stage companies. The thought process behind the clause is that when the investors are coming in, they are giving a particular value to the company. They are ascribing a value to the company, which otherwise the company would not fetch if
Yeah.
they were to raise a loan from a financial institution. And therefore, the founders or the management team have to earn those shares over a period of standardly it is 4 years. So 1 year cliff and 3 year vesting thereafter. So for the first year, no shares get vested, and over the next 3 years, shares normally vest in quarterly or monthly intervals. Market standard is now moving towards monthly for founders, but yeah, so that is there. If the founder is terminated or terminates his employment in the interim, that means that he has not earned all his shares, and therefore the shares which are unearned revert back to the company.
Yeah.
So that's the funda, simply put. Uh, this gives comfort to the investor that the founders are also there in the company for long haul, and they would build the company, because any VC funded company, people are expecting that the company would become a sizable business in 3 to 4 years. So that period gives investors that visibility that for at least 3 to 4 years, founders would dedicate all their time to the company, and by that time, they would also anyway companies' growth path would have been charted, and therefore things would be very simple for them from there.
Yeah.
Mhm.
So, same question, repetitive question. Vinayak, you already put light on it, but the question asked by Jayant Sanghi. What about background of investors? Do startups need to do due diligence on the angel investors to ensure that the capital is procured legally? So you can just give more light to that aspect. Before taking the investment from anyone, what kind of the things they should be aware of, kind of a pointer, 5 pointer, 10 pointer, you would suggest these are the things you should take care raising fund from the seed investor. Yeah.
Oh, sure. Then very relevant question. But this is something that should be done more informally if you are
Yeah.
talking about angels. Because
Yes.
for any institutional investor, it would be very easy for the institutional investor to give you their constitution documents, maybe not constitution document, but at least the incorporation documents could be provided to you, and you could know that yes, it's a legitimate investor, and then you would anyway know that this investor is active in the business otherwise. For angels, you need to just ensure that yes, you are taking money from you're taking clean money, not from the perspective that you may fall foul of any regulatory burdens, but uh, if you have taken money which is not clean, that may have impact on your growth of the business and future rounds. So that's something that you should always ensure, and this is more done informally, because you cannot, of course, ask the angel directly whether as what is the source of fund for this investment that you're making here,
But
and
yeah,
therefore, yeah.
with coming from private placement, I guess that point, because money came to be from a banking channel, that thing is quite, kind of irrelevant as on day, I would say, Vinayak. Correct me
No,
if I'm
so
wrong.
till banking channel is clear. Till
Yeah.
banking channel is clear. So it is coming from banking channel. You're not receiving money from in cash. So that
Yeah.
is very much clear.
But
What
cash is,
happened
I
before
think,
that?
altogether is avoided because no one can raise fund from
Correct,
cash.
correct, correct. But what about before that?
Yeah. Before that, yeah, I can understand.
Whether that money came from Hawala transaction, how do you
Yes.
ensure that? So that cannot be checked uh, as part of diligence on the investor if
Yeah.
the investor is an angel investor. That's the simple answer to that, Jen.
Yeah.
Hope this answers your question, Jen.
Hmm. Correct, correct, correct. Uh, one more, the last questions from my side is that how difficult, sir, you find to adopt the instruments that are globally available but are not legally viable in the Indian market. Example is cryptocurrencies. So legally, how you are looking that? So because the peoples are trading into this, so how legally it is valid? So what is your view on that?
So for now, Mohit, I can, as far as the Indian market is concerned, I can just say what is already known. People
Hmm.
are investing into crypto. There is no definite framework around this as of today in the country. Having said that, the interest that cryptocurrencies have garnered in India, and India being one of the topmost crypto, one of the topmost community of crypto traders, seems
Okay.
unlikely that there will be complete ban. But again, that's something best left to the government agencies to decide. Globally, I can say that crypto is quite active. This crypto sector is quite active, and people are making a lot of investments. Early movers would have definite advantage, but for a layman who do not understand properly, there's a concept of accredited investor in US, which means that you need to have a certain net worth or a certain annual income to be
Okay.
classified as accredited investor. And certain classes of securities, which are at times high risk securities, are only permitted to be traded by investors who are accredited investors under the Securities Exchange Commission Act of US.
Hmm.
So I would say that for laymen who do not understand crypto, exposure to cryptocurrency should be very limited. They should only expose as much capital as they may not mind losing when
Hmm.
they're into unknown cryptocurrencies. If you're investing into known cryptocurrencies, if you're investing into a Ethereum or any of the other known currencies like Bitcoin, I think that's more of a safer horizon to invest into.
And what about, other agreement like, safe note? We take an example for safe note. So in India, we are ultimately issuing, CCPS to against the safe note, but many founders, because Y Combinator, take out that document safe note, but that is not, perfectly viable as per the Indian law. But anyway, we are using that, and we are issuing, CCPS for that. So how you suggest that whether we should stick to these new things, or we should stick with the old method of SHA, SSA, or CC, debenture agreement? Yeah, what do you suggest?
Like safe note, whilst safe note may not fit well in all scenarios,
Yeah.
but for startups which are registered with DIPP, and
Yeah.
which is not a tough registration to get, we have been doing safe notes quite often.
Yeah.
For even Indian startups. So the only thing that you need to do is get a DIPP registration as a startup.
Mhm.
And that I think is very much doable by any company which is into tech innovation and all, which if you fulfill those criteria. So back there in 2012-13 onwards, I think we started doing instruments which were structured like a safe note, but were not safe notes.
Yeah.
I think that you and me also did something
Yes.
similar
Yes.
then.
Yeah.
We structured a transaction like that, right? So you have to be innovative about it. Of
Yes.
course, don't do anything which is illegal. But if just because an instrument is not currently recognized in India, and but still maybe not recognized as such in India, but legally it's permitted,
Yeah.
I think you should enable companies and investors to use that instrument.
Yes. So that
Okay.
was the thing. So we can still innovate ourselves with respect to global market by complying with the four parameter of law. Yeah, we can
Correct.
do
Correct, 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 correct.
startup
Uh,
industry is doing that for quite long. Yeah.
yes, yes. So Jitender, I have one more question. If you have any question, then you can ask. Otherwise, I have the
So you
last
can go
question.
ahead. You can go ahead, Mohan.
Okay. So it's a very basic question actually, for the benefit of our audience. Because in the startup ecosystem, everybody could not achieve their desired results. Maybe I think 80%, 90% of the startups get shut down and take exits. So, what are the important legal aspect one must be aware of while shutting down its business or company? So, because we are as a professional face some challenges with the startups because they have shut it down their business but could not close all the legal aspects, and they are facing challenges from the department side. So, what are the key metrics, key factors, key advice from your side while they are shutting down their businesses?
Mr. Mohit, I think this question is best answered by Jitinder.
Yeah.
Yeah,
Uh,
Jitendra ji, yes, you tell.
So yeah, so the shutting down of the business. So as rightly pointed out by Vinayak in the starting. So when you start your business, you should always go for you should start your company. You should always hire, right kind of professional. And when you are not aware about anything, you always seek the professional advice, and the professional, right kind of professional will always guide you in a way which will be more beneficial for you and the company. Okay, when you start stopping your company, so you should it's legally you need to be closed company, because it's need to be wind up it needs to be wind up professionally, legally, as per the Companies Act. So there are various methods, like you can strike off the company. If the company has nil asset and nil liability, you can strike off the company. And if the company is having asset and liability, then you have to move to the voluntary winding up, or you can go for the compulsory winding up. If the company is not able to pay off the liability, then you can go for the compulsory winding up by filing the application under IBC. Okay, and if the company is able to pay all the liabilities and assets are there, then you can go for the voluntary winding up. And if the company does not have any asset and liability, then you can straight for go for strike off. So these things can be done, but yeah, I can understand from which point, because they just shut down the business, and they just stop doing compliances and everything. And because
Yes,
doing for
yes, this was
for
my
going,
concern. Actually,
for going for
the process is very well known by
yeah,
all the professionals, but
yeah,
the problem is the startup guys who has started their business after 1 year or 2 year, if they are not making good, then they shutting down their business, but rest they give up all the things there and then.
So
They
the
are
same
not
thing,
clear about the
yes.
shutting down their business, shutting down their compliances, their registrations. So everything they lag behind, and after some time, 2 year, 3 year, 5 year down the line, they get the notices from the department.
So
So
so it's equally important to run a company when you are stop doing that. It's equally important to shut down it properly, then only to move forward, move ahead. Otherwise, it will hunt you in the future. Yeah, definitely
yes, yes,
haunt you in
yes,
the
yes.
future. Yeah.
Yes, very good insights from Vinayak and Jitendra sir, from both of
Yeah.
yours. So I
So
do not have any more questions.
So,
Jitendra ji, if
Vinayak,
you have any
two
questions.
question also we have in the chat box.
Sure.
Quite different. So, how startup can ensure that their talent is not being poached by competitors, or they're close to that clauses that stop employees from doing so?
So of course, all of us are aware of non-compete clauses that are there
Yes.
uh, in employment agreements. Stopping a competitor from hiring someone who has been an employee with you is slightly tough. You cannot stop people from hiring. Of course, you could go after them after they've joined and litigate, which is again a long path, and therefore, typically people would avoid hiring anyone who is bound by a non-compete clause.
Okay.
Again, more often than not, startups do make this mistake of not doing proper diligence on the employee being hired. Like when we diligence a company and we know that the founders have been employed previously in any other company and they have now started their own business, we always ask them a standard question that were you bound by any non-compete provisions in the previous employment that you were with this company? And if we get to know of this, we would normally seek a waiver from the previous employer if the business that they're launching now is in the competing business. So that's something that should always ensure. So maybe all employment agreements should have a clause regarding this, that employees cannot join a competitor. Practically speaking, this makes sense more for senior level employees or employees who are exposed to companies' trade secrets and not senior level employees. Even when I was at Shardul Amochan, we used to provide for different formats of employment agreements for senior level and junior level employees. Uh, for a front office manager, you may not want that person to be bound by a non-compete.
Correct, 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 correct.
For your CTO, you may want that to happen. So you should
Okay.
have that rationality in your approach when you have employees review or sign employment agreements.
Yeah.
Okay. So non-compete clause in the job agreement, our appointment agreement. So can safeguard this a little bit, but it is not a foolproof mechanism to safeguard this.
Yes.
Yes. Correct, correct.
Yeah. So one
Okay.
more question is there. How can
From Kabir.
startup handle deliberate trolling and criticism by competition? Can one file for defamation? So yeah, Vinayak, what will you
Yeah,
say?
so there are plethora of options available to any aggrieved party, defamation being one of them. You have to just fulfill the requirements of a fit case for defamation, and that's it. Many times you would see like spoof ads being run, which are questioned by other companies. At times, some companies may want to leverage the fame of another company, and therefore they may want to do ads which are called surrogate advertising. So yeah, these things are something that are happening quite often, and companies also seek remedies against such things by seeking injunction around this. So yeah, that's something that's an option always available to you, and you can pursue that.
Yeah.
Hmm.
So yeah, with some. So I would ask. I would not ask. Vinayak, we would ask you to give some more light if you have some, more to, guide us in legal aspect of the startup. So if any, I guess a bonus point if you want to give us to our audience. Yeah.
Yes, anything that you want to give your advice to the startup companies in the area of the legal and compliances. So please give us some bonus points, sir.
Sure, Mohit. So I think I would just advise that when you are that when you are starting a business, as I earlier also said, scaling the business to a particular level is of course important, but do ensure that in the course of doing it, you do not lose sight of things which are equally important which may not seem as important, but which are equally important and may come back and haunt you later. Seek advice when required, because you cannot be a champion of all trades. So, and
Correct.
there's no shame in asking for advice, seeking help from people. There are a lot of people available who would just go out of the way to help a budding founder set up the business, right? Multiple times you may see people doing a lot of pro bono work. My only thing is that you should avoid solving for things on your own, and wherever required, seek advice, because when you try to solve for things on your own, you may very well lose sight of problems that are associated therewith, and which you may not realize.
Correct.
Yeah.
Well advised, sir.
So yeah.
Yes.
I think we have more questions coming in.
Yes. Yes. There is no further question, sir. So,
Yeah.
I would request to Jitendra ji to
Yeah.
give you the formal
Sir.
thanks to Vinayak, sir.
No, we
We
can take
hope.
2 more questions. So there are, we can.
Acha, you want to take more
Yeah.
questions? Okay.
So there, so if possible, that type the tax compliances aspect of issuing capital on the premium. So that's a secure. It's a quite standard. If you are issuing the shares on premium, so if the company is a startup registration company, so you require only registered value valuation, and you can issue share on premium. So there will be no tax implication if the company is a startup registration company under DIPP. Okay, and if the company is not, then you have to take a valuation report from merchant banker. Then you can also not required to pay tax on the capital premium. If you are not taking any valuation report, then you are required to pay that capital. I would say that total premium will be added to your income of the company, so that will be there. But yeah, you have to, by right kind of certification or right kind of valuation report, you can avoid the tax on capital premium.
And also, Shikhar, multiple times you may have some losses in the books of the company, and even the money that you make out of this is offset against those losses. So there are multiple ways of handling this, and I would say that just because there is taxation linked to issuing share in premium, that should not be turned down as an option, and you should seek proper advice when structuring a particular transaction.
Correct.
So,
Correct.
yeah,
Correct.
and Piyush, when we incorporate our company, how we manage all type of compliances, how we focus. So Piyush,
Here
whenever
I want to say कि hire the startup stage or Jitendra ji. They will guide you.
so yeah, and Piyush, you can do one thing. So whenever you incorporating a company, always ask the professional, just prepare my compliance calendar, and he will happy to do that for you, and save that compliance calendar, and month wise you can see what are the compliances is there, and you can talk to the professional and you can get it done. So it's not there. Secondly, we have seen in many times, Vinayak, sorry to say, our professional fraternity also not doing their work properly. Okay, we have seen in many transactions, they just do one part of the compliance, one part of the transaction, and rest of the things they never guide them to do. Okay, and when we do the carry out the due diligence, then we will ask for those things, just basic as attendance sheet. Okay, so I would say ki professionals should also play their duty rather than just making the resolution or making the agreement. We have seen many time, we have done the private placement, we file the documentation with ROC, but rest of the documentation are not in the company record. So that is also problem, and many time we have seen the agreement is properly drafted, but the implementation under the Companies Act by private placement has not been done properly. So, and there is a huge penalty of 2 crore or 3 times the amount involved under 42, and that is a quite critical aspect we have seen in past also, Vinayak. So those things we should when we are taking a professional, it's for the professional, whenever they are taking a any assignment, they should complete in toto rather than just doing mandatory paperwork, I would say. Vinayak, you can also throw some light on this.
No, certainly, Jitendra. A lot of responsibility lies on the professionals who are advising companies in the early days, because mostly founders are unaware of compliances, at
Yes.
times scared of the compliances. And when people say compliance, people get worried. Like, even
Yes.
personally speaking, even for me, uh, filing tax returns is very important, and
Yeah.
everyone should file tax returns. But when you are busy in your normal life, that becomes one of your last items to do. So I always file my tax returns in the last week. So, and again, when I sit doing before I've done it, I always think that there is so much to do. As in, it will take entire day to prepare all the document supportings and all. And actually, when you sit doing it, you may be able to finish all the work in maybe an hour or so. So that's how simple compliances could be. It's just that you need to get away from the fear of compliances and the image that we have attached to compliances, that compliances means wastage of time. So that's something that I would just advise
Yeah.
all the members present here, that just because they're called compliances, you don't have to be afraid of them. In the long run, they'll help you a lot in streamlining the growth of the business.
Yeah.
And as much as possible, please try to accord it as much priority as you accord to the growth of the business.
Yeah. So thank you so much, Vinayak. It was a great, session, and for putting so much light on the practical aspect of the legal side and the compliance side, rather than theoretical aspect. So it's a very, very we are very happy to bring you here and to our audience, and thank you so much to all of the audience and all of the joining. So to make this webinar successful, if you have any query, you can write it to us at any time. We will be happy to advise. Okay. And with that, I would say thank you so much, everyone.